Over the last few weeks, we've been very fortunate. We've had 4 jury trials with 4 not guilties using 5 different attorneys from this office. Now, those results are not an accident. They're the result of hard work and dedicated preparation. Now, after every jury trial, whether we win or lose, we always have a strategy session where we debrief the trial lawyer to find out from their perspective what they did really well and what they might improve on if they had to do it again. So in this case, we thought we would record it and see what happens and invite you into the strategy session. So if you're interested, let's get to it. Over the last several weeks, we've had a banner few weeks. We had 4 jury trials in 2 different counties with 4 different judges, 11 different counts, 5 different, I don't know. A bunch of different counts, but all not guilties. 4 jury trials, all not guilties. So we thought we would invite you into our Outlaw University strategy session and talk about what we did well and what we might improve. So the first ones to get a not guilty were Kristen and Justin. So what were the charges our clients were facing?
Our case was 4 counts of criminal sexual conduct in the first degree, which is the highest level of a sexual assault in Michigan, and 1 count of assault with intent to penetrate.
All right. What did you do well?
Well, I think in this one it was unusual because of the nature of the charges. We decided to have 2 separate attorneys on the case, and that was allowed here. And so Kristen and I are very different as attorneys in sort of our styles and the stylistic way that we handle things. And I think that what we did really well here is combined our 2 strengths and weaknesses together to form the best team that we could for this client. A good example here is that Kristen is incredibly organized, and so by the time we're leading up to trial, she had already created a full trial binder that was completely indexed with a table of contents and hundreds of pages long. And that really helped me in my style, which is more of a on-the-spot type of person, to be able to do my style more effectively. And so that's something that I think I really appreciated and really worked well between Kristen and I, that she was able to have that sort of strength that I don't have. And hopefully I had a strength she didn't have. I don't really know,
I don't know what that is.
But ultimately, that was very effective, and obviously we won the case. So probably would have won it without her, but
Well, I will just say, so we struggled because we have such different styles. I was very nervous we weren't going to be able to mesh our ideas or come together on one theory or one theme, and Justin actually came up with those, and we did a couple ideas, and Justin had a couple ideas, and then he just hit it and everything kind of fell into place. And then that made any attorney who's ever prepped knows as soon as you can nail that down, then you can finalize your witness questions, your opening, your closing. So it really just helped us pull everything together.
Mm-hmm.
I didn't watch the whole trial. I watched a little bit and I watched the closing, which what Kristen did was excellent. I didn't see anything that could be improved in that. But maybe you did. What do you think?
Well, we talked about, because there are 2 people, we split all the duties in trial. We split who did opening, Justin, I did closing. We split which attorney was going to handle which witnesses for questioning. And when you do that, it's hard to make sure you are still being cohesive in your theme and your theory and getting what your partner needs from one of your own witnesses. So we did make sure we let each other know, hey, on this witness, Justin, I need you to get this answer or ask this question because I might use it in closing. And the same thing, Justin, get this question, Kristen, get this answer so I can use it with another witness. But I think what we could have done a little better is, even beyond just saying get this answer, is maybe explain why, because nothing ever goes how you plan in trial, and new ideas come to each of you in trial. And so if you know why they need the answer or why you want them to ask the question, then I think it would be easier for them to navigate when things don't go 100% according to plan.
Yeah, I'd agree with that.
Yeah. All right, a lot to unpack. I suppose I was the next one to go. My case was a civil infraction causing death. I think the thing that I did well is I think you can tell preparation is the number one. I knew that there were weaknesses in the investigation, so I was extremely prepared to dive into those weaknesses. I had everything prepped as far as if I needed to go to videos for clips to refresh recollection, so I didn't let the officers slip out of anything. We really drilled down on what they didn't do. And so that's what I did really well, I feel like, in that trial. A couple of things that I could have done better. Number one, there was the expert testimony in that case was critical from my perspective. We hired an expert and he did a great job. I talked to him a lot, so I knew all the calculations, I knew what he was going to say, and I again talked to him quite a bit, but I did not run through the testimony with him from beginning to end, which I usually do, and I think it showed in his testimony. It just was a little bit clunky. Obviously it worked and we got our points across, but I think by doing a full run through with your expert, you can communicate what you need to communicate to the jury much better, much more effectively. So I will not make that mistake again, and I'll admit that when I went to do my closing, I opened my file, because I have actually physical files with my closing in it, and I opened it and it was empty. I left my closing back at the office, so I had to wing it, so I'll admit to that. Apparently it worked, thank goodness for our client. But yeah, that's what I did pretty well, and those are a couple things I could have improved. All right, so who is next?
Me, please. Thank you. The trial that I had was in Berrien County, and it was 2 counts, an assault with a dangerous weapon and felony firearm. It was a big case going into it, because if my client was convicted of the 2nd count, he would have mandatory spent 2 years in prison. My defense in this case was self-defense, and I think what I did really well, it was a really fine line for self-defense here. Just to give you like a little bit of the factual basis, my client was at his home. The complaining witness came to his home and struck my client with his vehicle. The victim was then leaving the scene. He left the house, he pulled out of the driveway, and he was on the roadway. At that point, my client got his firearm out of his house and shot at the vehicle. Our defense was that he wasn't trying to shoot the complainant. He was trying to disable the vehicle, which was the weapon that had attacked him. But obviously the argument from the prosecutor on the other side of that was this guy was retreating and there was, no harm. There was no reason for my client to shoot the firearm at that point. So I had to really prepare my client for his testimony, because the way self-defense works and the way the jury is instructed on self-defense is, you have to look at it from the defendant's perspective at the time that this is happening. You can take into account the excitement of the moment, and you can even take into account, even if he misinterpreted what was going on. So I think I did a really good job at making sure that when my client testified, we really took it step by step. Like, you were assaulted, and then how were you feeling? What was going through your mind? What happened next? And we really drew out his entire thought process so that the jury could see it from his perspective and hear it from his perspective. And luckily, all of the evidence matched everything he said as well. And we really made sure of that. I went through with him all the statements that he'd made in the past. I guess in that same vein, another thing that we did really well was we knew we had certain weaknesses. Obviously, the complainant driving away was a big weakness that we had, and then the other one was that my client had lied to the police when they first got there. He had told them that there was no firearm involved. He'd never pulled the firearm out at all and definitely had not shot it. He eventually told the police that he did, but we really, I thought, needed to overcome that with the jury. right at the outset before the prosecutor threw it out. So I made sure that in my opening and that even during jury selection, I talked about why people maybe wouldn't be honest with the police to begin with. And during opening said he lied to the police, just so everybody knew. And that was one of the questions that I asked my client on direct so that we could deal with it in an appropriate way before they attacked it and made him look super not credible. So those were things that I think I did well. Things that I probably could have improved on. I had a plan for my cross-examination of the complainant, and when I got up there to execute my plan, I decided that I could do something different. I had like a whole new idea of how I could more effectively cross-examine him. There was a lot to impeach him on. He had a lot of prior inconsistent statements, and so in the middle of my cross-exam, I changed that technique. I guess is kind of a good thing that I did. I got a little flustered and I just stopped myself and collected myself and went back to my original plan. And that's not always easy to do because in the middle of it you think, oh my God, I'm gonna look like an idiot in front of the jury, right? Like they're gonna wonder why I'm fumbling. But I think the right choice was made to just go back to the original plan. Another thing that I think I probably could have done better is really hone in on the jury instructions with self-defense. Afterwards, I talked to some of the jurors, and at first they were all kind of putting themselves in my client's perspective in considering self-defense, and I probably could have really hammered more on the fact that they've got to look at it from my client's perspective. Other than that, I mean, he was found not guilty, so
Yay.
that was awesome. Yeah.
All right, a lot to unpack with all of these. Tony, last one to get an NG these last couple weeks.
There was no pressure.
No
yeah,
pressure.
No pressure.
No
yeah.
pressure whatsoever. So I had, my case had 2 counts. One was assault by strangulation and the other was a domestic violence. So one thing that I think I did well was just kind of being prepared for the fluctuations in trials. So I think as Kristen said, not everything is going to go the way you think it's going to go. And in particular, when the testimony comes out, there are things that you don't expect, even though you've got witness statements, you know what they said to the police, or you know what they said in prior hearings. Almost always it comes out a little bit differently. Sometimes it's important, sometimes it's not so important. But in particular, there was one piece of testimony or a fact that came out that on its face I think would have been pretty damaging to my case, but I kind of quickly turned it on the witness to say that she wasn't documenting everything. She reported an injury during her testimony, which could have been bad for my case, but she had not documented that in her report. And so that's extremely important. You need to document those things, and it shows that she was a little bit unreliable. So that's something I did well, I think, was being prepared to move with the fluctuations of the trial. Kind of in the same vein, something that I could have improved on maybe, was there were just a couple objections, maybe 1 or 2, that I think maybe caught me a little off guard. And you're not going to be able to predict every single objection that comes up or how the trial goes, but you never want to feel that way either when one comes in and you're just sort of sitting there for a second trying to figure out how to respond. So I had a couple of those that maybe I could just nail down the next time and be ready for them.
Yeah, good idea. I mean, that came up with me in a recent prelim that I just had, that something came up. It was unexpected, but looking back on it, I probably should have expected it and been a little bit more prepared for. So hopefully we're learning as we go. It's the practice of law, not the perfection of law, I suppose. So, all right. Anything else for the good of the cause?
Go team.
Go
Good
team.
work,
Wow,
guys.
4. Woo! All right. Let's see, all right, that was a good rehearsal. So let's, yeah, that was good.